Good morning, everybody. Welcome to the Courtroom Files Live. We're going to start off in Judge Shackelford's court this morning and see what she's got going on.
For 120 days. And if we want to set a bench trial for this, we can do this, but this is the final pre-trial.
Okay.
So we'll set a bench trial date. Can I voir dire your client?
Please.
All right, Miss Ayub, do you understand everything that's going on today?
Yes.
All right, and your attorney's indicated on the plea form that you're interested in a bench trial. Is that correct?
Correct.
All right, so you understand that you have a constitutional right to a trial by jury?
Yes.
And you understand that are you voluntarily waiving and relinquishing that right?
Yes.
And you understand that you're will be tried by a judge of the court, which is me?
Yes.
Okay. All right. I'm satisfied with the waiver of the jury trial. We'll set that bench trial. And I'm going to make, I don't know where we'll squeeze it in, but we'll try and squeeze it in pretty soon since she remains in custody on another case.
Thank you.
All right. I'll see everyone back. And Mr. Bobble, you will receive notice of that bench trial date. They're normally set on a Wednesday morning or afternoon. Okay?
Okay, thank you.
All right, we're all set, everyone.
Thank you.
You done? Your Honor, thanks for everything. Have a blessed day.
You too, thank you.
So while we're waiting for Judge Shackelford to take up the next case, my name is Dan. Welcome to the Courtroom Files Live. This is our inaugural show. I've done hundreds of lives at this point across several different channels, but there is a certain rule when you start something new, things go wrong. So bear with us these first couple of days as we get going. If you see things that aren't working quite right, please do let us know in the chat. And if you are out there, please do say hello in the chat. One of the things that we want to do with this show is have good dialogue, be able to talk through things, so let's be sure to do that. All right, let's get back to the judge.
All right, so we've got him here, and I know there were the 2 civil infractions that he met with Miss Manarino on, and then he has these bench warrants out, and it looks like he has a no valid license case that he's not appeared on or been arraigned on, civil infraction in default for 264, and then he has this case 0964 that he was sentenced on coming up on a year ago. He was given a payment plan and he's not complied with any of those terms.
That's correct, Your Honor. He is back to work, however.
All right, so as to arraignment on the new no valid license.
Plea not guilty, waive the reading, Your Honor.
All right, I'll enter a not guilty plea on his behalf. All right, so are we setting a pre-trial on this case?
Please.
All right, so that'll be set for a pre-trial. We've got that ticket in default. Plus you've got these other matters in default as well. I mean, Mr. Auld, by not taking care of this or just complying or even contacting the court, which I always tell people, just call us, we'll work with you. I mean, if you would have just complied, like you have a double parking, it was 165, it's up to 288 now.
Well, I understand. But
I mean, like you're
at the moment, so I can put everything behind me.
So, I mean, what are you asking me to do? You want a payment plan?
Yes.
I'll reinstate your payment plan, but you have to actually make payments.
I will this time, Your Honor.
And if you actually make payments at some point, if you're actually doing it consistently, we can talk about whether any of those late fees will be waived, but I'm not waiving anything when you're not paying anything
I'm
or
actually
making a good faith effort,
right.
right? I mean,
Yes.
like, if you don't have it, all you have to do is call us. And you call the court and say, I'm low this month, or I lost my job, we can delay it for a month, or offer you other options or community service. But when you just abscond and you don't comply, I mean, this is what happens. So make some payments so you can get out of the hole, and we can discuss, you know, potentially me waiving some of these late fees for you.
I understand. I was in a good headspace at the moment.
Are you doing better? Well, you showed up today, so that's a start, right?
Yes.
So let's try and figure this out. You got your payment plan reinstated. We'll set the other matter for a pretrial. And then I've got the 2 civil infractions here, 24AS 3151 A and B. And this is for no license for a dog or cat and no vaccination. And did you talk to the prosecutor on these?
Yeah, I don't have
Yes, Your Honor. As far as any pending cases, she's willing to dismiss those two civil infractions.
All right, so these will be dismissed. And then we'll see you back. And you know, when I see you back on your next date, I'm optimistic that you'll have made a payment to show me that you intend on acting in good faith. Okay, Mr. Auld?
Okay, what is the what is the whole amount?
Well, hold on, I need a calculator.
Yeah. Okay.
Yeah. I don't have my phone up here with me or a calculator up here with me. I've got 490, 312, 312, 288, and 264. So that's over $1,000. I don't have a calculator up here. I'm not known for my math skills, but it's a lot. But Mr. Auld, a lot of it's late fees. So if you actually comply, we can readdress whether or not I'm going to waive some of that. But you have to make some payments.
Okay.
All right, sir, you're all set.
Thank you, Your Honor.
Yeah. All right. This is 24TA00594A, B, C, D, E, and F.
Good morning, Your Honor. Paul
The
Robinson.
people versus state crushing. Wait, this one's state crushing. Counsel?
Good morning, Your Honor. Paul Robinson, number 3937, appearing on behalf of State Crushing.
All right, did you meet with Ms. Manarino, and was there any sort of agreement reached?
Yes, Your Honor. Pursuant to the agreement with Ms. Panarino, I will plead responsible to the aid charge and agree to fines and costs of $1,400, and upon acceptance of pleading responsible
On the D file?
A file. A is an apple.
All right, well, A is the defective tires.
The way I had it on my end.
All right. All right, I need Ms. Manarino. We'll get her in here. Can we get her in?
So just a bit of an explanation as to what's going on. They read off like charges A, B, C, D, E, and F. One of the things that happens in Judge Shackelford's court quite a bit, she's in Taylor, Michigan, which is right on the I-75, and there is a weigh station there where they often grab trucks that are coming and going from local businesses, and they find them overweight or problems with the trucks or things like that. And that's what's happening here. So just an FYI.
All right, so what was the plea offer on this case?
To plead responsible to the overweight violation with an agreed fine of $1,400 and dismiss the remaining matters.
1,400, that's the D file.
Yes, Judge.
All right, and Mr. Robinson, you have authority to enter into that on behalf of your client?
Yes, Your Honor.
All right, and to the, to overweight commercial vehicle in the city of Taylor on 11325, how do you plea on your client's behalf?
Responsible.
All right, $1,400, 30 days to pay, and the remaining files will be dismissed per the prosecutor.
Thank you.
Thank you, and let me get your files, Mr. Mays.
Thank you, Angela.
Thanks, Paul.
All right, this is 250142. There are also multiple civil infractions attached. This is the City of Taylor versus AG2 GLLC appearances.
Angela Maynard on behalf of the people.
And William Mays on behalf of defendant respondent. Your Honor, we've resolved this matter. The misdemeanor is going to be dismissed. Along with a couple of the defective equipments, they'll plead responsible to 3 defective equipments. I have authority to enter a plea of responsible on behalf of the client. And I would ask for 30 days to pay.
All right, so I've got the B, C, and D files are defective equipments. The E file and the F file and the misdemeanor will be dismissed per the plea. And you've indicated you would have authority. All of these are alleged to have occurred on January 11th to 25. How do you plea on behalf of your client?
Responsible.
Okay, I'm gonna accept the plea as knowing and voluntarily given. It's a total of $780. Your client pay in 14 days.
All right, Judge Fleischer's going live. We're going to go ahead and switch over to him.
Okay, and then I'll give you a heads up, assuming she shows.
Yes, Your Honor. Thank you very much.
Of course. Are you ready?
Judge, yes, we have
Let's
2
roll
other
this.
arraignments, but I don't know that council's here. Counsel for Leon or counsel for Navarro?
You guys, you don't have an arraignment, do you? Over? Okay.
It was, well,
Well, okay, so who's the first one?
page 20, top of page 20.
Okay, who's the next one?
The other one is top of page 22.
Okay, I don't have either of the phone numbers, so I guess we'll just wait.
And Mr. McGill, you're all set for the day. Have a good day.
Thanks, Your Honor. Have a good one.
Yes.
Okay. Yeah, see you guys.
Hey, come on up. Yeah.
You did?
We're waiting on lawyers, so come up, talk to me.
Oh, okay.
Yeah.
I didn't know if I could approach or not.
Yeah, of course.
Approaching on a case from yesterday, Helen de Alvarado Mejia.
Okay.
I was here yesterday. I talked to Blaze, got everything settled. We had a offer of PTI. Made a big blunder though, Judge. I forgot to reset the case. I took off without resetting the case.
Yeah, so
And so, well, it was moved to today and she's set for bond forfeiture today. Can we
she
reset
here
it?
yesterday?
No, her appearance was waived yesterday.
Okay, so you're accepting the PTI?
I'm sorry?
Accepting the PTI?
Yes, I talked to her yesterday. She wants to do the PTI. She's registered for it. So we're on
Okay.
track for the PTI.
All right.
Can we reset it?
Yeah.
Okay. Do you care about how long?
So, I mean, it's kind of old, right? It's from November.
Well, we got offered the PTI yesterday. I'm hoping for at least 2 weeks.
Of course.
Is that fine? Okay, thank you, Judge. I'll reset it then. Appreciate it.
Counsel for reset?
She is set for bond forfeiture and she's not here. Are we okay with that?
Don't worry about it.
Okay. Sounds good. Thank you, Judge.
Yeah, hi, Josh.
Yes, Josh. I have a very quick question for you on this Halbert Jones. It's Halbert.
Is Jones the last? All right, I see it. Okay.
Two last names, yeah, Halbert.
Yeah. Oof, that's an old case.
Right, so it's old. So we've got a PTI offer. She's made her donation and she's halfway through the 2-hour class. And we're just asking for one more day to finish the class. She's
Halfway through the 2 hours.
started on it last night and then is still trying to finish it up
All
today.
right, well, it's a tomorrow. I'm gonna roll it day for day until she gets
Understood.
it.
Yes, sir. Thank you.
Good job.
Did you get your videos?
We had an offer PTI yesterday. We did a short set.
What was the PCI? Okay. Our is 8
Excuse me, Your Honor. I sense a lull in activity. I just wanted to see if I could approach quickly.
Okay.
Judge, I forgot when Your Honor asked me. My client is in ICE detention, so she's not going to.
Do you have proof? If you can give me proof that she's actually in detention, then we'll just reset the case and we won't, revoke or forfeit.
Yes, Your Honor. If I could have a few minutes, I'll see what I
Take your
can.
time, no rush.
Thank you.
So while I sense a lull in the
There's a
action,
way-
one thing I
Mr.
want to
Moody,
point
there's a
out, because
way
it
to
often
look
comes
on
up
their-
in comments about Alex, the gentleman on the prosecution side, a lot of people are confused by him. He is actually a law student. So when he's up there arguing and what seems to be making decisions, he's actually under the supervision of the chief in the court. So he's not directly responsible for what goes on. Just something to be aware of. We've been watching him for months now. He keeps getting better and better, but a lot of people are confused by him. But he's actually a law student.
Amy.
I don't know if it was from today. What's the case number?
2533-502.
Oh, yeah, Judge, we're waiting on a PSR for Roger to come back.
Who's a lawyer?
Marco.
Adrogi?
But Roger's gonna approach.
That's-
He went to go to court too.
Okay.
PSR for,
Sagrado.
No.
No, it's a TV.
can I get the call number?
Oh, I texted it to you. 2533.
Oh, I see it. Thank you.
I saw a video that came with the community and about these. I don't need them to say. Don't want them on me if you only just. Am I good to send them to the future so they can process them and put them in the system? No.
We understand that all night.
Or should I just hold them for a day and then they'll give me that? I don't know, worry about it. Yeah. Ah, yeah. That's what I saw. There's a not me.
Hey. So I was thinking we would just do the time served on the one here. We'll just give you credit for whatever you have. And then the other one gets dismissed and then we will move. Yeah, okay, then done. So all we would need is just do you file the stipulations, right?
Yes.
You guys? Yeah, so and then how much, guys, how much credit does page let me see which one this is. No, he's on bond. It's page 7, but I don't know which one it is.
Miles Craig. The MHA or the?
The MHA, we're going, it's the MHA. The other one's getting this, so it's the 249K.
Yeah, 230.
What is it?
232.
It has 232 days credit, so you guys write it whatever, however you want, you know? I guess maybe 180 for 180 or 2, whatever you guys want.
Okay, that's.
Yeah.
Is it Easter hair growth?
Uh-huh, yeah, laziness. Thank you for coming back, Ms. Stewart.
Things are a little quiet in Judge Fleischer's court at the moment, so let's hop over to Judge Simpson's court because I believe he is doing his criminal docket at the moment. Let's see what's going on there.
For address the bond violation first to the pretrial.
Bond violation.
So Your Honor, at this time, Ms. Skibb is not going to contest the violation. She is going to admit the violation for drinking and testing positive on the silver link.
And Skip, why?
Your Honor, I'm very ashamed because this mistake was absolutely not indicative of the work I've been putting in the last few months, regularly attending meetings, and I'm very involved in the AA community in this area. I did an assessment by First Step Referral Services and was advised to complete inpatient treatment, and this is not at all acceptable, but the idea of having to be away from my son and the stress of this case on me, I allowed it to get to me, and when I messed up, I panicked, but I am currently at Dawn Farm.
You already have the violation.
And it is the 90-day program, correct? Yeah, so she's in the gold standard, the big one.
Well, I'm looking for my copy of the. I may have it. Was it from?
February 20th.
No, no.
I think that's the date of the violation that I have. Well, the report is dated the 20th, yeah.
And just as quickly as we switch to Judge Simpson, he gets dull and Judge Fleischer gets something going, so we'll go back to him.
Defendant stated that she swerved over and hit another car. She tried to exchange information and get off the roadway, but was not trying to leave the scene and only wanted to move the cars into the parking lot on the west side of the road. The officer observed a moderate odor of alcoholic beverage, glossy eyes, slurred speech, and swaying. The defendant was within normal parameters regarding her vital signs per Houston Fire Department, and standard field sobriety tests were then conducted. HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and consented to blood.
All right. So we have a DWI here. Any more DWIs anywhere else? If you run around and say, see, please.
She only had a previous out of 2022 here in court 5, but that's the only one, Your Honor.
Does she have a valid Texas driver license?
It's not eligible, Your Honor.
It's not eligible. I want to make something perfectly clear to you, Ms. Sawuma. I'm ordering you as a condition of your bond not to drive any vehicle whatsoever for any reason unless you have a valid Texas driver license and liability insurance. I'm also placing a restriction on your license that you're not to drive any vehicle that's not equipped with an ignition interlock. I'm sending notice to DPS in Austin so that every single police officer knows if you're caught driving a vehicle and it doesn't have an interlock in it, they will arrest you and put you in jail. Do you understand? And then I'm going to revoke this bond here as well. You will be signing an affidavit with me today. Counselor, did you want to add something?
I managed the wall. That's incorrect. The cop did not say moderate. He said mild.
Sure.
Yeah, Judge, a minor automobile accident and a mild odor of alcohol is not any kind of probable cause for intoxication. I believe what happened was the police officer noted she had a prior conviction and then jumped to conclusions and ran everything backward from there.
Well, we have witnesses who say that she's possibly intoxicated. They do field sobriety tests. The field sobriety tests indicate that she's intoxicated or potentially intoxicated. So that's when they do the blood test. This is just a mere probable cause hearing. We have someone who's got indicia of intoxication, slurred speech, odor of alcohol, crashes into 2 different cars, fails 3 different field sobriety tests. You've got 2 other witnesses that say that she's possibly intoxicated, who they're on the scene and see it. There's more than enough to go forward for probable cause purposes. Beyond a reasonable doubt, I don't know. That's why we wait for the evidence to come in. But I think that there's certainly sufficient probable cause to go forward. They say you don't have a license, so you may not drive at all for any reason. I don't care what your justification is. I don't care if Bambi has to go to the hospital. You need to save 30 kittens. A kid needs to go to you cannot justify getting into a car for any reason. Do you understand? This is an affidavit that you're going to be signing today, promising me you're not going to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months of jail and a $500 fine every time you drive because it's an offense in and of itself. Do you understand? Because you don't have a license, because we're ordering you not to drive, I am now ordering you to obtain a portable breath test device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol. You're not to consume alcohol, illegal drugs, unprescribed controlled medication, and we will randomly test you as well. Now, good job on having a lawyer because you have one. I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you because you're playing games and you're dodging phone calls, whatnot, I will issue a warrant for your arrest. All I'm trying to do is protect my city at all costs, and I will do it however I can. Do you understand? If that means putting you in jail because you become a public danger, I'm going to do it in a heartbeat. So for now, what I'm going to have you do is I will have you come up here, swear to us that you're not going to drive. Then I will get you to Victoria, where we'll have you sign a reset. You will get with Felicia for your bond conditions, and after that, you guys are free to go. All right?
Thank you, Judge.
Okay, guys. Thank you, sir.
Okay.
Here's the PSR for Salgado.
Thanks.
And then you have
What's
a
that?
motor vehicle that approved ignition and electric device properly installed in the vehicle. I need you to sign for this.
Roger.
Judge, may I approach?
Ready?
Yeah. The jury request, it's a walkthrough request.
Do you need an interpreter?
No, Your Honor.
You can have this, for you guys, you can actually see it.
So no priors? Roger?
Not to my knowledge, Your Honor.
Okay.
And who is this, Your Honor?
Let me give you cause number. You ready?
I gotta talk to,
533
yes, Judge.
02. And then I guess before we leave, if you can run an NCIC to see if there's any other priors.
I talked to Abigail, I'm sorry. No, no problem.
Salgado,
Yes, sir.
ma'am, you are charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Yes, Judge. The complainant and the defendant are mother and daughter, and the officers were dispatched to a residence in Harris County, Texas, in response to a family disturbance. The complainant told the officers that she arrived home to find the defendant packing her things. The complainant began discussing the defendant's life choices, which led to an argument. The complainant tried to get the defendant to stay at the home, but the defendant grabbed the complainant by the shoulder and shoved her against the wall, causing pain.
Ma'am, I'm going to find that there's enough probable cause to go forward with your case. Do you guys have the RIP done?
There is a rip done, Your Honor.
What
Yes,
does
Judge.
mom want contact with her?
It's my understanding she's okay with contact. She wants contact, Your Honor.
Is she here now?
No, she lives in a separate home. Since that incident, she's moved.
So I want you to understand something, Ms. Salgado. I'm now entering what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Gonzalez as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon. Do you understand? If you violate this court order, the state can and probably will file a violation of a protective order, and that is one of the worst misdemeanor cases that you can pick up. So just be nice. If you butt heads constantly, find another way. Go outside, do something else. But if you guys get into it again and there are threats made, you might end up back in jail. You understand? So this usually comes with a residential restriction that you cannot go back to the house. I will take this off. I am ordering you not to have any threatening or harassing contact with her. What is threatening or harassing doesn't matter what you think, it's what she perceives. So conduct in and of itself can violate this. You understand?
You can speak out. It's okay. I understand.
Do you mind filing another threatening or harassing?
Yes, Judge.
Please. So bond,
Judge, we are asking for $100 pretrial bond. She has no history. Once she found out about the case, she hired us, and we're here presenting ourselves and availing ourselves to the court's jurisdiction. I don't think she's a flight risk or a threat to the community.
Response?
And just, there is no criminal history, and given the complainant's statement to us, we wouldn't be opposed.
Okay, so I'm with you. I'll set bond at $100.
Thank you, Your Honor.
And then I'm going to grant you a PR bond. That means that I'm giving you a free bond today. But understand that I'm going to protect my community at all costs. If I find that you become a danger to my community, I will revoke that PR bond, issue a warrant, and put you in jail. No more. You will not get any more. Do you understand? Now, because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them, and they will tell you if and when you have to come back to court. Okay? All right, so I'll have you sign a reset with Victoria. We'll have you get with Felicia for your conditions, and then you're free to go. Okay?
Judge, may we be excused briefly?
So, PR bond and $100.
All right, Judge, we have no ranges. Page 12. Garrett, come on up.
Good morning, Mr. Garrett. Sir, you're charged with terroristic threat of a family or a household member. That allegation kicks it up to a Class A misdemeanor, so you are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On February 25th, 2025, the officers were dispatched to a residence in Harris County, Texas for a disturbance with an unknown weapon at approximately 5:49 p.m. And upon arrival, the officers met with the complainant, who stated she is the mother of the defendant and they live together. The complainant stated that day her healthcare provider came to her residence to help her as she is disabled. And the complainant stated the defendant was in his room playing loud music, and the complainant asked the defendant to turn it down while her provider was there. The defendant did turn it down, and as soon as her provider left, he turned the music back up. The complainant requested the defendant turn the music down again, and a verbal altercation ensued over the music and money, and the defendant started to rip up family photos. The complainant tried to stop the defendant, but the defendant grabbed the complainant by her arms and pinned her against the wall. The complainant stated she did not feel pain, but that the defendant said to the complainant that if she continued to touch him, that the defendant would break the complainant's jaw. The defendant was on the scene and refused to speak to officers.
Okay. Mr. Garrett, I'm going to find that there's sufficient probable cause to go forward with your case. Do we know what mom wants?
See if a rip was attempted, Your Honor, and unsuccessful.
We have a call scheduled later this afternoon. She won't be available until afternoon.
This is a problem. I normally order in these types of cases that you're not to go back to his place. So if you don't have anywhere else to go to, what happens? You have to be careful in these situations, Mr. Garrett. So let's do this. How old are you, sir? I'm going to give you a lawyer today. I want you to talk to the lawyer so we can figure something out. I don't want to put you out on the street, but I got to protect every person here. You understand? So I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using anything, I will revoke your bond, put you in jail. You understand? You're not to be in possession of weapons as well. And you're not to have any threatening or harassing contact with mom. If I find that you do, likewise. You got out of jail because we gave you a free bond. What happens if we put it at 5,000 to 10,000? If you don't have anyone to bond you out, you'll be stuck like Chuck in there until this thing's over with. And it takes a long time just to get a 911 tape. You understand? So I'm going to have you sign a reset. Let me have you take a seat in the jury box. I'm going to find your lawyer and then we'll go to it. Come on. Good one.
Couple things real quick. First of all, you could make a drinking game with Judge Fleischerism. Somebody should probably do that. But real quick, I want to flip over just a view of what's going on in Judge Simpson's court and look at the bottom window there. That is the Michigan Department of Corrections where they're zooming into, and check out the like 4 different cages that they've got there. I just found that interesting because most of the time when they zoom into these jails and prisons, they're in like a room. Here they've got these actual cages. I don't know what facility in the MDOC this is at. ICF or JCF, it looks like it says. I'll try to look it up. But it obviously appears to be a little more maximum security than what we normally see. So just found it interesting. Thought I'd show you because we don't often get a look inside prisons to see these kinds of setups.
And Judge, if this is whenever you get a chance, the log is right here.
Just looked up what we were talking about. ICF in the Michigan Department of Corrections is the Ionia Correctional Facility. So, the more you know.
Did you want to ready?
You want one? If I need to put them on down, it's in
We can hear.
And then. Yes. Yeah, I see
Mr. Moody, you ready?
Yes, Your Honor. I have
Do you want
the,
to send, if you can send it to Victoria, her email,
okay.
I'll take a look at it.
Yes, Your Honor, we'll do that. Thank
And
you.
then we'll get you a date.
Okay, Judge, I will send it to
Please.
Victoria. Thank you.
Hey, Vic,
Yes.
on Mr. Moody's case, he's sending you an email with the ICE stuff.
Okay, I'll forward it to you.
No. Just open it and you need to do it.
There's something attached. It's like an email that we type. That's why it's legal.
No. Mr. Moody, there's a certain, like, I don't need you to type what happened. There's a printout from ICE, like an actual web page that says on theirs, yeah, hold on, let me see that. Hold on. That's it.
Yes, Judge. This is what I was going to send to Miss
Okay,
Victoria.
I got it. All right, that's good enough for me.
Oh, okay, thank you, Judge.
Yeah. So what day do you want? I don't care. You, whatever you want.
Whatever would please the court, Judge, sometime in late April.
Hey, Vic, what are we looking at? I saw what he showed me. That's good. It's all good.
Judge, how is April 29 or 30?
April 29th to 30th.
Yes, Judge, I'll take the 30th. Thank you.
Okay.
So if she does get out, if you guys are able to secure her bond and she's able to get out, we need her here to sign conditions.
Yes, Your Honor.
I just need her here for the initial arraignment, and after that, we'll waive it. Okay?
Yes, Judge.
Okay, thanks.
Thank you, Your Honor. Have a good day.
Take care.
Thank you, Judge.
Hi, Brandon. You ready?
Judge, how you doing?
What's going on?
Judge, I have a plea.
Can you stretch up that on the order to as well?
Brandon, what you got, man?
Your Honor, it's a plea on Mr. Wiley.
Okay.
There you go.
You want to bring him up?
Yes, sir.
Yeah.
Thank you.
Absolutely.
Yes, sir.
Good morning, Mr. Wally. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement. They're offering you 6 days in jail with credit for the 2 days that you've done. Are you sure you want to do this?
Yes, sir.
I guess the prior evading is what,
Sir, we talked about everything, wanted to
just,
do this, Your Honor.
you need to understand that this has lifelong consequences. You know, you're entering into this agreement where this DWI will go on your record. It's going to be there for the rest of your life. It's even there after you die. The reason this is important is because if you get pulled over in the future, an officer will look at your record. They're going to see that you have a prior DWI. If they roll up to your window and they smell alcohol, they smell dope, it's probably not going to go well for you. Do you understand?
Yes, sir.
And from now on, what we're doing today, the proverbial slap on the wrist, from now on, it's a minimum of 30 days in jail. Do you understand?
Yes, sir.
So what I'm trying to tell you is that if you want to get lit, just don't get into a car because it's a huge risk you're taking. You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this, it's done forever. This is what you want to do. How do you plead to the offense, sir? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I will send you to the agreement. I'm going to suspend your license for 90 days. Do not drive until you get a license. The other thing is this, Mr. Wally, is that DWI is big business. There's a $3,000 surcharge that tacks onto this because you pled guilty to this. I'm going to waive it for you today. But the DWI second is a $6,000 surcharge. So if you're not smart enough to consider how to get home on a night of drinking, get ready. It's minimum 30 days and a huge surcharge. Do you understand?
Yes, sir.
All right, good luck.
Your Honor, could you run the LR suspension, or the suspension concurrent with the LR suspension he already has? He had a suspension from October to April. We have the dates. 6 months, Your Honor.
I don't know, man. He has a prior abating that
No,
just,
that was the same transaction. They dismissed it, I believe, like the day after. It was. the
it's
same-
out of the same, okay, all right. I will. Okay, all right, you got to get them the dates.
Yes, sir.
All right,
Thank you.
good luck, sir.
Thank you, Your Honor.
You got it, man. Hi, guys, come on up. Yes, sure.
I'm here for Mr. Thering on Jesus Lopez.
Okay. In jail or on
He's in
bond?
custody, Judge, and he has felonies pending. Fairly serious felonies pending. In this court, apparently they had offered a PTI for this particular case, but the prosecutors just advised me that that's been withdrawn. So I'm,
Not a big thing.
so Judge, Mark's got medical issues going on this morning. That's why he's not here. We just
Yeah,
wanted to
tell
see
him we're
if we
sorry
could.
that he didn't come by, you know?
I'll see him probably later this afternoon, but just wanted to see if we could reset this case.
You want,
Go ahead and set it for the same date as the felonies.
we cannot do that because he's in
Yeah.
custody, but the day after.
I don't know a lot about felony cases, but Mark didn't imply that there was a good potential that those will resolve, which I think will take care of this case as well.
Alex, any offers in the felony cases or
No, Your Honor.
there's still no offers?
No offers.
Okay, all right, so we'll set you for the day after then.
Thank you, Judge.
Assuming it's on the Saturday, let me see, sure.
Have a good day, man. Be excused.
Give me a second, let me make sure. Okay, yeah, it's a Friday. That's
Thank you,
cool.
Judge.
Okay, for sure. Ms. Strong. Hi,
How are you doing?
what's going on?
So I have Kimberly Hillshine on docket today for Kimberly Hillshine.
Okay.
She's here for an arraignment. She's on bond. She's not here. I will be in the building until noon if she shows up.
So she picked up 2 trespasses?
No, they refiled. So they dismissed the misdemeanor B, the regular criminal trespass, and then they kept the
It's
criminal
not
trespass.
dismissed yet.
Mhm.
It's not dismissed yet. Hey, Blaze, do you mind taking a look at this? Blaze,
I thought
on
it was
Hillshine,
so yesterday or sometime, the criminal trespass was the class.
Yes.
I got the dismissal email, but it's still looking like it's not dismissed.
yeah, yeah. No, it's already been refiled as an A, so we need the B dismissed.
Yeah, I'll refile the dismissal, Your Honor.
Okay, yeah.
Okay.
The thing is, she's not here.
She's not here. I will be in the building.
Say it again?
I'll be here until like 12 if she shows up, but she's not here. So, I mean, you have to.
Do you have contact with her or no?
I've never met her. I did a deep dive search to try to get a cell phone number.
How'd you get appointed then?
She showed up on the mental health docket list, and then I filed the appointment form for her.
Okay, I guess if she's not here, I'll set it at 2501. And then if you ever get a hold of her, or when we get a hold of her, you want to stay on it or do you want to? What do you want to do? It's up to you. If you want to stay on, happy to have you. If not, then.
I'll stay on. I'll see if my investigations department can try to find her. If by.
Okay. Yep. Oh, you want to sign? Yeah. Okay, don't file it, don't file
I just did it. I guess
it. Okay, so just delete the new one.
So I guess I'll recess in like 30 days, see if I can get a hold of her or not, and then.
Oh, no, she's not even, wait a minute, I'm just gonna revoke it.
Exactly, yeah.
If you get a hold of her, bring her in and then we can address everything.
All right.
But I don't want to just leave it,
Yeah, I'll stay on it until, I'll try to find her.
got it.
Thank you, Judge.
She shows up, I'll call you.
Okay, sounds good. Thank you.
Thanks.
Okay, that's fine.
Hey, while there's a break in the action here, I just wanted to say can you hear me now? So it looks like from my end you can hear me now. And I was just actually explaining that one of the things that happens when you start a new live stream and you start a new program is there are bumps. There are things that go wrong. There are things that are out of your control. And that's funny because that's exactly what I was talking about, how things will get smoother and better as we do more of these. So thanks for pointing that out and thanks for bearing with us. Yeah, like I was trying to explain when apparently I was muted, is we've actually done hundreds of live streams across some other channels that we do, but anytime you start something new, invariably stuff goes kitty wonkus on you, as we just demonstrated. But the point I was trying to get across was thank you for those of you who have tuned in. Thank you for joining us, and appreciate it. And I just had one of the Courtroom Files team come in here to tell me that they also lost audio because they were monitoring the stream. So everybody's on top of it. All right, let's get back to court.
They're all the wet men. No, it's gonna be
Hey, Trey.
Hmm?
For Salgado, is it still showing inactive for you? I'm looking at J one. I need the bond not in here. It's probably because they have to ramp up it. I see.
Oh.
This
is the bond has been signed.
No, one second. Oh.
I don't see that the PR bond popped up on J-Web.
You're good. I'm about to order him. You have time for case with me?
Of course.
This first one looks fun, so I'm sure you're gonna want a motion. Did you wanna look at it first? Okay. This second one, her clause is 248.
Okay.
1956. She's supposed to get off probation on April 23rd.
Okay.
They removed her from thinking for a change because she missed 2 classes because of work. She's re-enrolled, but the next class doesn't start until April 12th, and she's gonna end on May 9th. So they wanted a 3-month extension.
Yeah, that's okay, but
Okay.
I'm not gonna continue this.
Okay, at one time. Okay.
Sure.
And then this is a similar situation. His probation ends April 1st. He has to complete effective decision making and a driver safety course. He's telling the probation officer he's completed it, but they don't have a certificate. So they wanted an extension for this one as well.
How long? Were those the only 2 things that this person had? And he worked for the last freaking second?
Mhm.
And he has no proof?
No proof. You want to admonish him?
Yeah.
Okay.
Yep, bring him
Thank
in.
you.
Thanks.
Whatever amount or whatever credit. On that. The other one is kind of like. Or not multiple things. That one is just going to be, has to live in creature. Yeah, Judge. I'm just, that doesn't make sense. Oh, it's the. Oh, so it's.
No, but it's, okay, it's after
Oh. Yeah, I'm sure you want that one.
I'll show you. Oh, yeah. I thought you. Oh, no, that would have. Salgado? Let's go grab lunch. Sometimes I just eat out. Right. I'm gonna go with my important stuff that we actually have to sign. And what you're signing is just an information sheet for pretrial services, and that's your policy is specified. So just sign for them. Part over there. And then since we processed the RFA, let's clean up one thing. So.
Judge, I have Moses Garza on today's docket. We've been going back and forth about PTI program. He just doesn't think he can afford it.
For the DWI?
For the DWI PTI judge. We've been talking.
I'm going to switch over to Judge Boyd's court. She just started a trial, State versus Lopez, and looks like the first witness is on the stand. Probably a little more intriguing than what we currently have going on in Judge Fleischer's court, where there's always a lot of pauses about this time of day. So let's flip over there and see what's going on.
Law enforcement officers.
Yes, ma'am, in the state of Texas.
And
How long did you say that you've been with SCPD?
A little over 2.5 years now.
Okay, and you've been assigned to the patrol unit for your entire career?
Yes, ma'am.
All right. And so I want to turn to the day of May 8th of 2023. Were you employed as a police officer with SCPD and assigned to West Patrol Dog Watch on that day?
Yes, ma'am.
All right. And were you in uniform?
I was.
Okay, and were you in a marked patrol unit?
I was.
And were you on patrol on that day?
I was.
And can you just describe to the jury what your duties are as a patrol officer on duty?
My primary duties as patrol officer is to respond to calls for service. We also do a little bit of proactive work too, which is interdicting with crime before it actually occurs.
And were you dispatched to 257 North Santa Lucia Avenue in San Antonio, Texas, 78237?
Yes.
Do you recall what type of location that
It was a residential.
was? And was that located in Bear County, Texas?
It was.
And do you recall why you were dispatched there?
We were initially dispatched for an assault in progress call.
Okay, and did you write a report that is associated with that call?
Yes, ma'am.
And would you like a copy of that to refresh your memory?
I already have a copy up here with me.
Okay, thank you. Can you tell me the SAPD case number that was assigned to the incident?
Yeah, it's going to be SAPD 23100593.
Okay. And can you describe to the jury the scene that you encountered upon arrival at that address?
Upon arrival, I initially located what appeared to be a wooden handle, something that came from a shovel of some sort, and then a pretty significant initial blood trail that led to the house where I located the victim on the front porch.
Okay, and when you located the victim, what was he doing?
The victim at the time, he was screaming out for help. He kept saying, "Don't let me die." He was on his hands and knees.
Objection, hearsay.
All right, the objection, do you have a response to hearsay?
Incident excited utterance.
All right, if you'll lay the foundation.
So just going back a little bit, so you described that the victim was on his hands and knees. And what was his demeanor without explaining what he said?
He appeared very scared and worried. He also had a lot of blood coming from his face. I initially observed the injury to the front of his face, which was near his left eye. It appeared that he had a laceration. Upon further looking at him, I also observed a laceration to the back of his head.
Okay, and so while on scene, what did you do?
On scene, I initially spoke to the victim. I requested medical aid because of the extent of his injuries. While we were waiting for EMS, I got a story from the victim about what he remembers happening.
Okay. And so did EMS arrive and take custody of the victim?
They did.
Okay. And I'm gonna first show you a couple of photos. Oh, I'm gonna tender to defense for inspection first.
Is that black one? When you prove them up.
All right, and on the day that you made the scene, were you wearing a body worn camera?
Yes.
And were you competent to operate it at
Yes.
that time? Did that capture the scene fairly and accurately?
It could have, yes.
And so I'm going to show you what's been marked as State's Exhibit number 1. Have you reviewed this before?
I have.
Okay, and how do you know that this is the same thing that you've reviewed?
I signed my name and badge number on it.
Okay, and so when you viewed this, has it been altered in any way besides to comply with the legal rules?
No.
Okay, and so that's a fair and accurate depiction of what happened from your body worn camera on that date, correct?
Yes.
Okay, and I'm going to show you these photos as well. If you just give me a minute. Now I'm going to show you what's been marked as State's Exhibits 2 through 6. If you can take a look at those, please.
Okay, is State's Exhibits 2 through 6 a fair and accurate depiction of the scene on the date of the offense?
Yes.
Okay. Your Honor, at this time, the state moves to enter State's Exhibit number 1 and 2 through 6 inclusive.
Any objection?
Judge, I'd like to take him on board dire for a second because I believe these are duplicitous of the same things that are on the body
All right, you
camera.
may take the witness on board here.
All right. The still photographs you have are that came off your body camera?
I believe those came off of the detective's photos, sir.
Okay, so you didn't take those pictures?
No, sir.
All right. So you cannot testify exactly what the scene looked like concerning those pictures because you weren't there?
I was there on scene, yes, sir.
Okay, with your body camera?
Yes, sir.
All right, but the separate pictures you did not take?
I did not take the pictures.
I'm going to object to the pictures, Your Honor, not the body cam.
All right, State's Exhibit number 1 is admitted without objection. In regards to State's Exhibits 2 through 6, do you have an answer to the defense's objection?
My response, Your Honor, is that this officer was present on scene and he's testified that they're a fair and accurate depiction, and so that I believe that they're admissible.
All right, then State's Exhibits 2, 3, 4, 5, and 6 will be admitted.
Thank you, Judge. All right. And Your Honor, may I publish State's Exhibit 1?
Yes. Do you need the mouse? And ladies and gentlemen, I may move around as well so that I can see what's being presented.
I am playing State's Exhibit number 1, starting at 040720.
Let's go back to Judge Fleischer's court for
I'd
a
like
minute.
there to be an affirmative, okay, there is an affirmative finding of family violence in this case. You need to understand that this is very, very important because another case like this, there's an affirmative finding of family violence in this case, meaning you can never own a gun or ammunition. The other thing you need to realize is that if you pick up another one of these like this, you could be very well facing a 3rd-degree felony. And because of the pen trips, you pick up another 3rd degree, you could be looking at potentially a 5 to life case, maybe 15 to life. So that's what I'm saying. Be careful. Do you understand? They're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement today, there's no turning back. It will go on your record. It's going to be there forever. Like I said, there's an affirmative finding of family violence. So you can never own a gun or ammunition as a result of this plea today. Also, the next one, you could be very well facing many, many years in prison. You understand?
I do.
Does he still want to do this? How do you plead to the offense of terroristic threat of a family or household member? I'm gonna find you guilty. I'm gonna sentence you to the 50 days, give you credit for the 9. Please, just let them be. All right? All right. Good luck, Mr. Lopez. Thank you, counsel. You too.
To add a little bit of context to that, as we were flipping over, Judge was admonishing him on how he treats what sounded like his mother. So apparently this terroristic threat was against his mother from what we can gather.
On Lopez, I just want to bring to your attention, I'm looking at deeds. I only see the state's motion for the MOAB. I don't see it.
I specifically did a MOAP in this case last time. I don't know why it's not signed.
I thought it was addressed.
And I don't see it signed in deeds. Because the motion was on the 26th.
I did it the last time we were here in court. The hell, I need a fly swatter. You see that?
Yeah, I do.
Do you got a fly swatter?
Oh, I don't know.
So I'd like to enter it in then,
Not close to it.
you know? So I want to undo the plea.
Okay.
I'm going to enter in the MOA and then we'll do the plea again.
Yes, sir.
Because I want to make sure that there's no issues with this family.
Yes, sir.
All right, coming up, Mr. Lopez.
You got it.
So I didn't sign the plea.
There's no entries, nothing.
Okay,
in-
so hold on, let me do the MOA first. So I'm entering in what's called a magistrate's order of emergency protection that identifies Ms. Solis as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Bower Creek residence. Do you understand?
Yes, I do.
If you violate this, the state can and probably will file a violation of a protective order. This includes you cannot text them, you cannot message them, you cannot use social media to reach out to them, you cannot use, Snapchat, you cannot use someone else to try to get in contact with them. No contact whatsoever. Do you understand?
I do.
This order is good for 61 days from today. So if you go over there, it's going to be an issue. You understand?
I do.
Okay, so I want to sign first now the MOA.
Okay.
And then after that, we'll now do the plea again.
It's
It's near you, Judge.
Mr. Lopez, I want to protect every person in my county, and I'm going to do it at all costs. Do you understand?
I do.
All right, so let's do this plea again. You're now charged again with the offense of terroristic threat or of a family or household member. You're facing up to a year in jail and or a $4,000 fine. They've offered you 50 days in jail, credit for the 9 days that you've done. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers if you're not a citizen. There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. There is an affirmative finding of family violence. How do you plead on this case? Guilty or not guilty?
Guilty.
I'm going to find you guilty. Now we will sentence you on the case. All right. Good luck to you, Mr. Lopez. Make me proud, man. That's all I'm asking you to do. All right.
On Salgado's bond conditions, we removed the address restriction on the MOAB, but we didn't want it on the bond conditions as well, right?
No.
Okay, I'll have them recall.
Yeah, okay.
Judge, I wanted to approach on a fugitive case. I wanted to see if we could bring him out.
Sure.
It's Mr. Cordell Jackson.
I'll let the bailiff know right now. So just have him. Someone else approached on this, did they not yesterday?
We were here last week on this one. I don't know if somebody today or last week.
Another lawyer approached on this case.
Really?
Remember.
I'll bring back kids.
I'm thinking of another case. What would you like to do?
Judge, I wanted to approach to see if you would reconsider a fugitive bond.
Okay.
Yeah.
Are they bringing him out?
Yes, yes, they're bringing them out.
While we're waiting for this defendant to come out, we are still monitoring the trial over in Judge Boyd's court, but to be honest with you, there's all sorts of stops and breaks going on, so we're just kind of keeping it in the background for the moment. They keep having objections, they keep muting audio, and it's just not moving smoothly over there at the moment, so we're going to stick with Judge Fleischer.
So, Amy, we spoke about this last week.
Yes, Judge.
I denied him a bond last week.
Yes.
Has anything changed?
No, Judge, it's the last thing I don't want.
Tell me, I don't even remember. What does he want it for?
This warrant from Broomfield County, Colorado for failure to appear for burglary. It was issued in October of 2023. He's also here in Harris County for evading other vehicles. He also has other criminal history that we can go into, but it would need to be offline stream.
Okay, I remember that. Okay.
Judge, yes. First, criminal history. I don't know how much we should go into that. We are here.
Don't go into anything that's.
No, just
We're going to.
it's not something I want to go into anyways. I don't think it's relevant to whether or not he's gonna turn himself into Colorado or not. I think if we focus on that, the argument is that he would like an opportunity to go turn himself into Colorado for this pending case. He hasn't been found guilty out there. He's presumed innocent. He would like the opportunity to go turn himself in. He hasn't messed up in your court before. He hasn't been given that opportunity before. And he is not asking for a PR bond. He's asking for a bond sufficient enough to guarantee that he will go turn himself in over there. He has family members here in court today showing their support for him. He's got 3 family members. After talking with them, they are inclined to help him make a bond as well. They understand the risks. He understands the risks if he doesn't turn himself in over there. He understands the complications of having to meet his court date deadlines. And so we are just asking for you to consider giving him a sufficient bond to go turn himself in.
Who's here? Mom?
Judge, we have his sister, stand up, please. We have his sister-in-law, his girlfriend, and his cousin. Sister-in-law, and girlfriend.
Thank you for coming, God. Really, I appreciate you coming. You're welcome to come up if you want.
And these are the family members that would be responsible for helping him post the bond. They would be posting the bond for him, and they understand the risks involved.
Sure. Hi.
Hi.
Thank you for coming. Thank you for coming. Thank you for coming. You know, and I told this to Mr. Jackson about a week and a half ago. There are several things that I look at when I give someone a bond. One of the things I look at is their prior criminal history, what they have done, how old they are, and whether they've left a wake of just destruction in their path. Mr. Jackson is very young. He's what, 20, 22? And in the short time that he's been alive, he's managed to rack up a ton of cases. Just here in Harris County, an evading that was dismissed in 2021. He picked up a felony theft in 24, an evading arrest in 24. He has a fugitive case out of another jurisdiction of another state. And now he picked up here 2 weeks ago, another evading arrest. So the common theme that we have here is I'm going to take off and I'm going to try to evade. That's the common theme that we have. And The two things that I don't want are, number one, I don't want him to pick up another case. And most importantly, I don't want my public to be in danger. These are the things that I consider. What is he wanted for out of state?
Failure to appear for burglary.
And now he has another burglary in another state for failure to appear for that. At what point do we say when? So my point is that the problem is that if I give him a bond and he just takes off, all you guys are going to lose out on all that money. And what happens if he picks up another charge? So these are the things that I consider. And this is why I denied him a bond the first time, is because what the common theme that we have here is that in the short time that he's been an adult, there's a ton of evading and flight cases. That's why I didn't want to give him a bond. Because in my opinion, he already has 3 flight cases. Do we need a 4th? And that's what scares me. Carter.
Judge, considering all that, considering his family's here, we would be asking for an amount that ensures his attendance in Colorado. I think by putting an amount on his case, it would ensure that he hasn't had this opportunity before. He hasn't had a risk of losing money before. This risk would ensure that he does what's right and turns himself in over there.
But he has, though. You know, he has. He got out in Colorado, failed to appear on that. He's constantly trying to evade, you know, here as well. It's a constant thing. And I can't continue to say, okay, it's okay for you to do this. La, da, 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 da. It's not okay. The bill comes due. Do you understand? At 22, you have all these cases. Life is hard enough as a young Black man in today's society as it is. And now with all this, really? You want to pat on the back for all this? You want me to just, no. Now the bill comes due.
Judge, if I may, respectfully, one of the things that I wanted to do was look into the Colorado system to see if it was actually a failure to appear or if this was a sort of like a 2B warrant here in Texas. I wasn't able to log into that system over there, and I don't think we can make the distinction on whether or not it was a 2B warrant based on the documents that have been filed, or if this is one of those situations where he missed a court date.
Regardless,
Okay.
all we have are someone constantly trying to evade capture. They're trying to evade police one way or the other. I have a feeling if I let him out, the same thing's going to happen, you know, and I don't want that to happen. I don't want you to pick up a 4th case, 5th case. I certainly don't want anyone to be injured. And that's it. At 22, all this baggage, it's not going to happen, man. The bill comes due. I certainly appreciate you guys coming. I know that you've taken a lot out to be here today. It's just too much baggage. I'm sorry. Okay. Thanks, guys.
Thank you, Judge. Thank you for your consideration.
Of course. Anton, Tony. Hey.
Clarissa Leon Borges.
Is it under Leon? Oh, I see it. Okay. So what's the word?
She has a TRAS appointment today at 1 o'clock.
Okay.
So hopefully
I'll
after
take you off
that.
like 2 weeks. Everything's in, Alex, right?
I'm double checking, Your Honor. Yes, Judge.
Okay, so we'll set you off like 2 weeks for you guys to get the contract back, or after the TRAS, you get everything, then you get the interlock, pay the BA for me, and hopefully,
Great.
2.5 weeks is enough, huh?
All right, sounds good.
Okay?
Thank you, Judge.
Makes sense. Sean, please. Huh? You want me to get off the line?
Or, yeah, either video or mute.
Alrighty, so I fixed the audio problem that I had when I went to Just Me earlier, so we've got that handled. But Judge Fleischer, since he stopped streaming on YouTube, acquiesces to the lawyer's demands. If they want the live feed cut, the live feed gets cut. But there is stuff going on back in Judge Boyd's court with that trial, so let's go back there for now. Hang tight a minute.
Like 2 days.
And did you receive a diagnosis there at University Hospital?
Yes.
Okay, can you describe the injuries that you sustained from the attack to the jury, please?
The first injury was back here in my head, and the second one was right here on top, right here. So when this opened, and then on the third one, it hit me right on the eye, and that's when I had already fell. And he caught me one more time, like in the mouth, and then I fell.
Okay, and so regarding your eye specifically, did you have to have surgeries for your eye?
Yes.
Okay, and ultimately what happened to your eye?
Well, actually, yeah, it came out of the socket, and so my eye was like hanging out, and so the doctor, they said he will try to save it.
Objection, Your Honor, hearsay.
All right, that'll be sustained with regards to what the doctor said.
So you just can't say what the doctor told you, but you can say your experience. And so you said it was falling out of the socket, and ultimately, was the doctor able to save it?
My eye's there, but he said I'll never be able to see again.
And did you have medical bills that were associated with your hospital stay?
Yes.
And have you been able to pay those at all?
No, no, ma'am.
Okay.
It was a pretty good amount.
And then just, I'm gonna approach the witness. Okay, Mr. Eskew, I'm gonna show you what's been marked as State's Exhibit number 7, State's Exhibit number 8, and State's Exhibit number 9. Do you recognize these photos?
Yes.
And have you seen them before? Earlier today, maybe?
Oh, earlier, yes.
Okay, and are they a fair and accurate depiction of you at the time that they were taken?
Yes.
Tendering to defense for inspection.
Objection.
All right, States Exhibits 7, 8, and 9 are admitted without objection.
Mr. Esquivel, can you tell me what's depicted in State's Exhibit number 7?
Can you repeat the question? Or-
So this photo, State's Exhibit number 7, is that you in the photo?
Oh, yes, ma'am.
And do you recall where it was taken? Was it at the hospital?
The hospital. Yeah.
Okay, and the shirt that you're wearing, what is that shirt?
That's the bar I was working at, those guys.
Okay, and that's the same Los Gallos that you were at on the night in question?
Yes, ma'am.
Okay. And State's Exhibit number 8, is that a photo of you in the hospital?
Yes.
Okay. And State's Exhibit number 9, is that a photo of the laceration sustained to the back of your head?
Yes.
Okay. And the home that you ended up at where the people called 911 for you, were those individuals involved in the offense in any way?
First one was an off-docket
So
matter,
they just called 911 for you?
and the case number,
But they didn't see
case number is
anything.
25-30952.
Now I have some questions about the property. So the bike, you said the bike and your cell phone, did you ever recover those?
No.
Okay. And can you tell the jury where you got the bike from?
From me that night when I was riding it home.
Yeah, like when you initially received it, who gave it to you?
Oh, another friend of ours that we worked at that party rental place.
Okay. And what was that friend's name?
Joey.
Okay. And when you received the bike, was it in good working condition, or did you make some changes to it?
Objection, Judge, leading.
Overruled.
When you received the bike, was it in good working order? Or once you received it, did you make some changes or alterations to it to improve it?
I just had to fix the gears on it. It was,
Okay. And do you know how Joey got the bike that he gave you, that Schwinn bike?
yes.
Okay, how is that?
Well, Joey had lent Jose his bike, and he said that Jose left it.
Objection, Your Honor, hearsay.
Sustained.
You can't say what Joey told you, but you can
Okay.
talk about what you have personal knowledge of. So, okay, just going back a little bit, so you said that, what happened with Joey's bike and the defendant?
His bike got ran over,
Whose bike?
Joey's bike.
And who had Joey's bike when it got ran over?
Jose did.
Okay, and so because of that, did Jose owe Joey something?
Well, yeah, he had to.
Judge, I think we're getting into speculation here.
Sustained.
Okay, and so ultimately, the bike that you received, who gave it to Joey?
Jose did.
Okay. And so, then Joey gave the bike to you, is that correct?
Yes, ma'am.
Okay, and so how long had you had that Schwinn bike? Before the.
About 2 months.
Okay. And, was the night of the attack, was that the first time that the defendant had seen you with the bike?
No.
Okay. And had you seen the defendant before the attack?
Yes.
Do you recall about how many weeks before?
About 2 weeks prior to that.
Okay, and can you tell us about that interaction with the defendant?
Like I was going the same route home, and he was outside, and he called me, like, so we were just talking just like fine, like anything, like nothing.
And so you had seen the defendant before and he had never made any mention to you about him having an issue with you having the bike, is that correct?
No, he didn't have an issue, but he did tell me that he knew that he owed Joey a bike, and
Um. Judge, can you approach?
Yes. All right, ladies and gentlemen, I'm going to give you a short break. I'm going to give you till 10:55. You've heard some evidence in this case. You're not allowed to discuss anything that you've heard. You're not allowed to start deliberating. You're not allowed to do any research. Everything that you need to know about this case has come from inside the courtroom. Does everyone understand? All right, everyone, please, Deputy Laura, if you'll take the jurors.
Okay, so they're going to go on break. We'll cut back to Judge Fleischer's court here in a second, but her admonishments of the jury kind of reminded me of something. Mrs. The Courtroom Files and I were watching The Lincoln Lawyer the other day, and if you haven't seen that show on Netflix, it's actually really good. Give it a look. But one of the things I commented on was they had shots of the jury, and as things were being stated, they were like looking at each other and shaking their heads and making comments to each other. And I pointed out to her that that's just not something that's allowed to happen. jurors are not allowed to discuss the case or in any way, shape, or form until they actually get to the jury room. So I just thought I'd mention that with the admonishments that she gave. So let's go ahead and get back to Judge Fleischer's court.
Is this Mr. Garza? You're going to pay for it one way or the other.
That's what one way or another, I know I'm gonna have to pay for it. It could be, this sound bad, but
Problem is that
trial's gonna make
this,
it worse.
when it goes on your record of what you're doing today, it will hose you in many facets of life. Your insurance is going to go up. It could affect potential employment. So DPS is going to hit you. It just, whereas with this route, if you're able to do the PTI route, you know, you can get some stuff waived, but at the end, if you complete it successfully, the case gets dismissed. Once you plead to this case, there's no turning around. And we've got a fly swatter. We got a fly swatter.
And the thing is, the fly is huge. Judge, you were a defense attorney at one point in time. You know this is probably gonna be the best deal, to be honest with you.
I can't give you legal advice.
No,
That's why we gave you a lawyer.
And Judge, the issue with the PTI has been the financial aspect of it.
Here.
Yeah.
It's right there.
Sorry.
We've talked about the PTI and he just says he can't afford it. And so that was kind of my recommendation.
Gonna
was
get hit.
The PTI if you can afford it.
Yeah, one way or another, it's not. How much can you waive, Blaze? Guys, on a PTI, DWI, how much can you waive as far as fees and stuff?
My understanding, the only thing they can waive is the DAO fee, Judge.
On PTI, I think they'd have to get special permission. My guess would be through division chief. I think they could work with defendants.
And Your Honor, another issue is that his license is not eligible, so he'd have to also pay the fines associated with correcting that before.
Well, he could do the no driving affidavit.
Suspended?
It's currently, yes.
Oh, okay.
Of the ALR, but you can probably do the no driving affidavit and stuff.
We'd also have to reach out to the DPO.
Yeah, and I don't know kind of I think that they can work with them on it. So if
Counsel,
counsel
what
can
was
reach
that?
out to Ashley and see like what.
Will they pay for alcohol monitoring device, Judge? I don't think they'll do that.
That, I don't think so. So the one fee I know that you'll probably have to pay is the interlock fee, which is the breath test device fee. That's usually around $70 a month. Can you swing that? Are you working?
Yeah, I'm working, but on top of everything else.
And he pays child support right now, Judge.
That too.
I mean, if I could pay for it, I would. I just can't. I mean, do you want time to think about it, or you want to? Look, why don't you guys step aside? Just make sure this is what you want to do. If you want to do it today, I'm happy to do it. If not, I can give you more time where you can, talk with the division chief to see what you guys can do to reduce the fees. It's up to you, but I don't want you to make a decision in front of everybody here. Just take your time. Just
Stand down and talk
know,
about that, Judge.
because once you do this, there's no turning around. That's it.
Thank you, Judge.
Please, just take 5 minutes. Hi, Counsel. Of course.
One time, good to see you.
Hey, what's up?
Judge, I'm standing in for John Paul Cedillo this morning on
Okay, yeah.
Dasaki, DASSAKE.
Okay,
Judge, so by way of context, note here from John Paul saying that the client was attempting to apply for the PTI. Mindful that this is now
yeah, we've been working on mitigation since,
180 days by my count.
well, since December.
Yeah.
Is this person here?
No, appearance is waived for today.
Let's do this.
Yeah.
I'm gonna give you 2 weeks. The defendant must be here with packet in hand and let them know that if they're not, I'm gonna carry him day for day till they get the packet done.
Got it, Judge.
Yeah?
Yeah.
Okay,
Sounds good. Maybe excuse. Good seeing you.
you got it. You too?
There you go.
Thank you.
Mr. Madrid.
Yes, good morning, Your Honor.
Hey, good morning.
Hi, I'm approaching, let me make sure I have the right case I'm telling you. But the other day I approached to move this case from, well, actually I was on the phone, I think, on
On
Zoom.
trial or something like that?
Still in trial.
Okay.
And he's on the docket tomorrow. I think we're gonna be done, do it to Friday.
Sure. How about Monday?
Can I do it a week from Monday? Because it's spring. No, I could do it Monday. I'm gonna be here. Okay,
Wonderful.
then we'll do
Happy to
it.
have you.
Right.
Yeah, I'm gonna get that damn fly. I'll tell you what.
Not as big.
So we'll do it Monday.
Yes.
No, I'll let her.
Where's it? You see it?
It only comes whenever you're ready for.
It's a big one too. Like I'm gonna knock over coffee and.
What's the last thing? Oh, these are many. I just do a call.
Judge, what is Mario trying to do with the case?
Just
Move it to Monday.
move it to Monday. Christopher Torres is the name.
It's a trial case?
No.
No.
I'm in trial in another court.
Oh, okay, okay, cool.
You scared Ramona.
Okay.
Yeah. Okay, Torres.
Monday the 10th. Separate. Yeah, I saw that one. This is the second one. Okay, got it.
Thanks.
Yeah.
You heard other one?
No, I don't think any.
We never did the plea on Craig, huh?
On Fred?
Your Honor, on Craig has told me that she's looking to find him because he's currently out of the building and.
Your Honor, we have come to resolution.
It's just no, not sure. That's what they are. The court record will be back at the. Then.
I'm going to go ahead and switch over to Judge Simpson's court. He just returned to the bench from recess. Let's see what's going on over there.
Is that if you're confused when you sign?
What do you want me to do?
It's regards to the county.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Christian Ramirez.
Sir, this is court's understanding you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
I do, sir.
All right. And understanding that, do you still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind?
I do.
All right. You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
I do not.
You look on the podium, please look at paragraph 5. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
I do not.
Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce?
No.
Doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes.
On November 5th, 2024, at the location of Washtenaw Avenue, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes. Prior to operating that motor vehicle, did you consumed intoxicating liquor?
I did.
What did you have and how much?
2 shots of tequila. Last drink was at 9 p.m.
Okay. Were you stopped by the police or was there an accident?
I got stopped by the police.
All right, why'd they stop you?
I was picking up my friends from the bar, and while my friends start walking home, so I park Spice Street Apartments, and while my friends got out of the car, trying to tell him to get in the car, so that's why the police stopped us after that.
They stopped.
Yeah, they thought like it was a
All right.
fighting.
Were you ultimately arrested?
Yes,
And were you taken to the hospital or police station?
yes, I put the hospital.
Hospital, was there a blood draw?
Yes.
And do you know what the results of that blood draw were?
0.12. 0.12. Yeah.
Pardon?
0.120.
120. All right. Do you have any reason to dispute those blood test results?
No.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate the motor vehicle was visibly impaired due to your consumption of alcohol?
No, but I know I did a mistake driving like that.
So, Mr. Ramirez, remember how we talked about this charge is saying that you drank alcohol and when the cops arrived, you appeared intoxicated?
Yes.
Okay. So do you believe that your ability to operate the motor vehicle was visibly impaired, meaning somebody else would have been able to notice that about you?
Yes,
You
I
do?
do. Yes.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendants referred to Von Schwartz for an alcohol screening assessment, and the victim's impact panel sentencing in this matter will be April 9th, 2025, 9 a.m. Bond with its conditions will continue. All right, sir, stop down the hallway at probation, check in there, okay? Let them know that you entered a plea.
Thank you, sir.
Thank you. Court does call the case of the people versus Ava Tompkins.
Mr. Riser, on behalf of the people.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Tompkins, who should be present via Zoom.
Yeah, I'm here.
There she is. All right, state your name, please.
Ava Tompkins.
Your Honor, I'm respectfully requesting, I believe, just a very brief final adjournment. I have discussed this briefly with Ms. Londi. I know she's out sick this week, so I believe we will be able to resolve this matter at the next pretrial.
March 19th, 2025, 9 a.m. Bond continued. All right. Thank you, Ms. Tompkins.
Thank
you, Your Honor.
Court calls case of the people versus Crystal Turner Ned.
Mr. Riser, on behalf of the people.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Turner Ned, who is present via Zoom. Ma'am, can you please unmute and state your name for the court?
Crystal Turner Ned.
Thank you, ma'am.
So, Your Honor, there is a resolution in this matter that I worked out on speaking with Ms. Londi, which that Ms. Londi would be allowing Ms. Turner Ned to admit responsibility to the civil infraction of failing to stop, and the misdemeanor license charge would be dismissed.
The failing to stop an assured clear distance.
Yes, the civil infraction. Yes, Your Honor.
Get my fines in there. Okay. Is that a correct statement, Ms. Ryan?
Yes, Your Honor. Thank you.
All right. What are you talking? Okay. All right, Ms. Turner Ned, do you, just looking here. Yes. Do you admit responsibility to the fact that on January 18th, 2024, at the location of westbound I-94 near Carpenter Road, Pittsfield Township, Washington County, State of Michigan, that in operating a motor vehicle, you failed to stop in a shared clear distance?
Yes, sir.
All right. Court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $120. When can you get that paid?
And I have until the 3rd of April. I'm the caregiver for my family. And I just need, well, that's when my husband get paid. on the 3rd. So
Pay it by April 4th,
thank you.
2025.
Thank you.
Thank you.
Appreciate you.
Yep, take care.
Thank you,
Thank
sir.
you, Your Honor. Thank you, ma'am.
Thank you.
Court calls the case People versus Natasha Olmos.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Almost in the case ending in 1426, which is set for pretrial and expecting appointment on the other matter.
Ms. Olmos?
Hi, Natasha Almost. I'm here.
Okay, there you are. Gotcha. Okay. It's almost, I'll start with the case ending in 250092. You're here for arraignment. And it's a 2-count complaint. Actually, a 3-count complaint. The complaint alleges that on or about October 5th, 2024, location of Gulfside Road and Washtenaw Avenue, Pittsfield Township, Washtenaw County, State of Michigan, that you operated a motor vehicle while intoxicated with occupants less than 16.
Correct.
Do you understand the nature of that charge, ma'am?
If you could explain it to me a little bit more, I'd appreciate that.
All right. What that charge indicates is that you did operate a motor vehicle upon Gulfside and Washtenaw Avenue, and that Camilla Penley and or is it Julia's Almost, that they were persons less than 16 years of age were occupying the vehicle at the time that you were driving that vehicle while intoxicated. Does that make sense to you?
It does make sense. The only thing is only
Hey,
my
hold
daughter.
on, ma'am.
Anything about the case?
Ma'am.
Oh, I'm sorry.
I'm not here to ask whether or not you did it.
Okay.
I don't need to know your position necessarily on the charges.
Okay.
What I'm asking you is, do you understand what you are charged with?
Yes. Yes.
All right. That is a misdemeanor punishable by a fine between $200 to $1,000, not more than 1 year in jail, 30 to 90 days community service, or both. You could also be ordered to pay the costs of the prosecution, could be ordered to any rehabilitative programs, and could be required to reimburse for any emergency governmental services and or expenses, including your prosecution in this case. Your vehicle is also subject to forfeiture and or immobilization. You understand that those are the maximum penalties, ma'am?
Yes.
Count 2 alleges the offense of child abuse in the 4th degree, alleging that you did knowingly and intentionally commit the following acts, which is driving while intoxicated with a minor child in the motor vehicle. And that those posed an unreasonable risk of harm or physical injury to the child. Do you understand what you're charged with in regard to child abuse 4th degree?
Yes.
That's a misdemeanor punishable by up to 1 year or probation up to 5 years. Do you understand the maximum penalties?
Yes.
Count 3 is the same charge of child abuse in the 4th degree, which you said you understood. You understand that?
Yes.
That's also, as I've indicated, a misdemeanor punishable by up to 1 year or probation up to 5 years. You understand that?
Yes, Your Honor.
First question I have for you is, do you wish to be represented by an attorney?
Yes.
This is a public defender case.
Yes.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Almost, I would waive any further reading, stand mute, ask for a PR bond as well as an adjourned pretrial date. And not to speak too soon, Your Honor, but I would ask for the April 2nd date for both cases, if Your Honor would allow.
Got it. Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. Alleged BAC in
Your Honor, in this matter, the alleged BAC was 0.186. The PBT on scene was 0.237, notably. The lab results also indicated presence of THC 3.3 nanograms.
Got it.
We are asking for a scram tether.
Yes. Yes, ma'am. All right. Set the defendant's bond at a $10,000, oh no, I'm sorry, a $20,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior and no possession of any weapons. You understand that, ma'am?
Yes.
There's also to be no possession of any or consumption of any alcohol, recreational marijuana, or any illegal drug. You understand that?
Yes.
I'm also going to order that you are to report to the Department of Community Corrections for placement on a scram tether. You are to do that within 24 hours. I will be signing the order momentarily for you to report there. You understand that?
What is a scram tether?
It's a tether that will monitor whether or not you are using any alcohol at any given point in time.
Okay.
I'm also going to order, as part of that, you'll be on a scram tether. And then because of the THC in your system, you have a medical marijuana card?
I do not.
I'm also going to order urine tests be performed 1 time per week. So I've signed that order,
Okay.
right? I will adjourn both of these matters to April 2nd, 2025, 9 a.m.
Okay. Thank you.
Thank you.
Thank you, Your Honor.
Okie dokie, we're kind of at a hard out for today, so we're gonna say goodbye here in a moment. But first, I wanted to say thank you for joining us for the first live episode that we've done on this channel. Little bumps here and there, as I explained earlier. You're gonna have those anytime you start these things, no matter how many times we've done it before on other channels. It just happens. Appreciate you working with us. I want to say too that the goal of this live show is to bring you intriguing courtroom interactions as they're going on. So we're going to hop from court to court. We're going to try to find the most engaging stuff that we can, the best stuff that we can learn from and enjoy. Every day is going to be a little bit different. It's going to kind of depend on what's out there, but we're monitoring multiple things at once, try to move through them. Obviously, we all have our favorites, like Judge Fleischer, for example, Judge Simpson, so we'll definitely be watching those courts, but we're going to try to bring in some others that you haven't necessarily seen before too. And we'll just see how this goes. We're going to keep getting better at it. That's one of the goals that I personally have with everything in my life, is we keep trying to get better and better. So bear with us as we continue to improve. Again, thank you so much for tuning in. I do have a heart out. I need to go for today, but we will be back tomorrow, same time, and we hope to see you then. Thanks so much.